All right, welcome to IANYA Chat, where I am not your attorney, but I am an attorney, and therefore am qualified to give an incisive and intelligent and informed commentary on intellectual property issues in pop culture. But I will not be giving you any legal advice, because as I said, I am an attorney, but I am not your attorney. So let's see what we have today. It appears to be Shark Tank.
Hello Sharks, my name is Phil Dumas and my company is UniKey Technologies. I'm looking for a $500,000 investment for a 33% equity stake. My product UniKey is the revolution of the key. I'm going to incorporate your key into your mobile phone. And now you can take this big old bulky keychain and get rid of it. It's that simple. As long as I'm in range of the lock, I can control it. Now I simply walk out of range, and Mark, if you could do me a favor and just hang on to my phone/key for me, you can see just a regular user has no control over the lock. They can only lock it, they cannot unlock the lock again. So if somebody leaves, they can lock the lock for you. Cool? Now if I come back into range, you'll see I gain access again. This is me walking up, I gain access to my lock.
Wow, I have one of those in my office. I don't know, I don't have to tap a little thing. I have an RFID in my wallet, and I bring it up to a reader, and it changes from red to green, and then and then I get in. Now his is very different. Obviously, his light is blue rather than either red or green. I feel there must be more to it. I think we need to see more to justify his comment about revolutionary new technology.
Now another unique thing about UniKey is by having the key on your phone, we can send and receive keys to and from other users on a one-time, extended, and permanent use basis. So if you have a friend coming to town and gets home before you, you can send them a one-time key. If you have a maid service that comes over every Wednesday from 2 to 3 p.m., their key can work for just that period of time. But more importantly, at any time, you can delete these keys. It's that simple. So with your help, your capital and experience, we can change the access control market. Thank you very much for your time. Are there any questions?
So I have a question. My question is, from an intellectual property perspective, what can this person protect and what is he protecting? So I'm looking at it, there's a lock. It had two little things you touch on the top. Maybe there's some kind of mechanical thing in there, right? A new sort of mechanism. You can potentially patent that. Maybe there's some manufacturing for that, some process for installing it into a door. He didn't really go into it, but then again, this is Shark Tank, not a technical exposition, so there was no reason for him to do that. My other question, though, is what's he going to have to show that he is innovative relative to? So in order to get a patent, you need to do a number of things, but for innovation's perspective, you need to say, okay, this is novel. That means no one else has ever done the exact same thing before. And it's non-obvious, which means that it's not something that, okay, it's not exactly what's been out there before, but if you take some pre-existing pieces and you can combine them, you're not really doing more than just someone of ordinary skill in the art would have done and would have expected to work. That's not, by the way, a legal technical definition, but it's close enough for our perspective. The reason I mention obviousness, though, is because he's talking a lot about physical keys, revolution in physical keys. And if I were looking at it, I would be curious what kind of access control for software and other kinds of systems exists out there. So, for instance, if you're a database administrator, you will give different people different levels of access, and those access credentials can be revoked, right? You give people revocable access credentials. That's really old in sort of the software database administration roles art, although maybe not in the physical key art. Now, for obviousness, the question is going to be, are these arts analogous? So if what he's got is methods that are old hat in sort of software electronic access control, but not physical access control, and he's simply moving them over to the physical access control area, the question is, why would that not have been obvious to do? Now, I will say, from what I know of the sort of access control in technology, I haven't seen what he's talking about in terms of, say, a maid service. You only have access from 2 to 3 in the afternoon, these 2 days a week, right? The granting and revoking credentials is very old, but the sort of very specific time-limited keys are different. And there may be some different implementation details. As an entrepreneur, he's going to want to have some kind of intellectual property to make sure that if his business blows up, it's not just ripped off. And a patent is a great way of doing that. It's access control for the space of the mind, because he will have a patent which can lock other people out of his innovative market niche. All right, let's see what we've got.
I'm actually working with Black & Decker right now.
Can you use the regular original key on that lock if I want?
Yes. So if your phone dies or you don't have it with you, we recommend you keep a key laying around, or one of your neighbors. You can just walk up and use a stick.
Yeah, that's a security best practice. Much like what you do in your office, where you write your password on a sticky note and then IT comes by and says, "What are you doing?" But I guess the best practices in physical access control are a little different from the best practices in software, where that will get you a nice email talking about how you can get some remedial training. Anyway.
Is this patented?
Now, there's the question, right? Let's get past all the glitz to the patents. That's the real meat of the issue.
All-inclusive provisional patent filed, which part of the equity money that I'm raising is going to use to take that into a non-provisional status.
All right, so before we go too much farther here, I just want to mention, he says there is a provisional, all-inclusive provisional patent application filed. He wants to take it to non-provisional status. So a provisional application, let's say I don't have a lot of money. All right, so I haven't gotten my investment yet. That's why I'm on Shark Tank. Well, I still want to be able to get patent pending status. I still want to be able to sell and market and promote my product without worrying that I'm going to do something that might make it publicly available. And that can decrease or eliminate, I guess, your ability to get a patent. In the US, you actually have 1 year from when you make it publicly available that you can file your patent application. But let's say he wants to file in Europe. They don't have a 1 year grace period in Europe. So if he wants to preserve his rights, he wants to get something in, but he doesn't have the money to put together this full non-provisional application that says, here's what I claim, it's going to have some drawings, it has a lot of formal requirements. What you do is you file a provisional application, which can be identical to a non-provisional, although if it's going to be, then why not just file the non-provisional? But also, if you don't want to do that, you can just file the description part. So you can say, here's how to make and use my invention, but you don't necessarily say, here's what I claim is my innovative method or innovative machine or innovative product with A, B, C, and D. It describes kind of all the aspects of his invention. Maybe there's a new method, like the method of putting the bolts in the door. Maybe there is new software, there's new machinery perhaps. And it reserves his right to file a non-provisional application, which then will claim the novel, innovative aspects of those things. So that's my guess as to what it is, but that's what a provisional is, and that's what he's talking about when he says he's filed one of these.
So I'm working with Black & Decker on a licensing structure. My technology, their lock, their sales, their marketing.
Why not go to Black & Decker, raise the money from them for a 1 year exclusive in the market?
They don't fund the development.
So when he says they don't fund the development, I'm a little curious what development he still needs to have funded. And there's two reasons for that. One, he has this demo that appears to work. And two, he has a all-inclusive provisional application. And a provisional application, it's only good for what it discloses. So if I disclose some invention in a provisional, and then I come back within a year, file a non-provisional, it's treated as if it was filed on the day of the provisional, and that's good, right? Because then I didn't lose my European rights. But if he's still developing it, if there's a new thing that he comes up and invents, that provisional isn't going to cover it. Now there is sort of legally, you don't need to describe how to make it commercially. So let me rephrase that. You need to describe it in how to make and use it in the best way that you know of. But that doesn't mean that you have to have a commercially viable thing that you describe, right? So let's say you describe how to make a lock with components A, B, C, and D, and then you describe the best way to make and use it that you know of at that time, and then later you develop a different technology for making it at scale. Right now, that different technology might be its own invention, but it's not going to invalidate what you had previously. What the additional development is potentially important from an intellectual property perspective, and it can also be important from the perspective of what additional filings he's going to make in the next 12 months or however many months he has left in that provisional, because he may want to do sort of supplementary filings to keep the earliest possible filing dates for any new innovations that he happens to come up with while he's making the new developments.
I really need $1.1 million to hit profitability. Now, the $500,000 is I'm calling round A, and then there's an extra $600,000 tranche.
Let's be clear, that doesn't get you to profitability. That simply gets you to end of proof of concept.
No, the 500 does. The extra $600,000 gets us to profitability.
So how are you going to use that $500,000?
The first 500 is patent protection.
Wow. I would love to get a $500,000 budget for patents. That's a huge number. So let's talk a little bit about cost. So he's already got a provisional filed. In theory, he might use that to prepare the non-provisional. Non-provisional applications are going to vary tremendously according to what the technology is. You're probably looking somewhere, let's say $16,000, which would be reasonably expensive. You have your US filing fees. So let's say he puts in the fast lane. That might be an extra $4,000 plus regular filing fees, maybe another $1,000. So you've got about $20,000. Then you have to go through and you have to negotiate with the patent examiner. So let's throw that up to 42. We've gotten to less than 10% of his patent budget here. So these are some really aggressive numbers, very much on the high side, I would say. But I think that illustrates just how high his estimate is, because $500,000, that's a heck of a lot of money for intellectual property protection. Certainly worth it, but man, that's a lot of money.
$500,000, that is the absolute minimum. I can take it from point A to point B, and there's a little bit of cushion in there, but to be honest, I'd like a little bit more.
I'll put $100,000 down. You still have to raise $400,000 from other sharks, but I want the end deal to be for 50% of the company.
I'm going to take up Kevin on his contribution, and I'll provide $400,000. So in aggregate, it's $500,000, but we want 45% of the company.
40%, we have a deal.
I'm in.
I'm in as well. You have a deal.
Wow.
Done and done.
Good for him. He got a deal. Yay. He got $500,000 for patents, so good for somebody, I suppose, probably his attorney. I am very curious what's going to happen with those patents, and in particular, what the patent office is going to say is analogous art, for the purpose of saying, is this obvious? Is it just going to be physical keys, or is it going to be physical keys plus like computer security, where role-based permissions, granting limited purpose credentials, revoking the credentials is a thing, obviously more than you have with the physical key. He needs an attorney who's going to be able to talk about all sorts of things, physical keys, computer security, etc. Interesting stuff though, good result for him. Hopefully everything goes well with him and his business and his patent. Anyway, it's been a pleasure, and I will talk to you guys later. Bye-bye.